So, what is it that actually makes a law a law? I mean, is it just because a government says so? Or is there something, deeper going on here? We're about to dive into this huge, fundamental debate that gets to the very heart of where legal authority even comes from. Just think about that for a second. If a rule is profoundly, deeply unfair, or just plain immoral, does it still get to be called a law? Does it still have that same power? This one single question, well, it's the battleground for the two major schools of thought we're going to break down today. All right, so our first answer to that question comes from the theory of natural law. And the big idea here is that true law isn't something that's just made up by people. Nope. It's something we discover from a source that goes way beyond any human authority. At its core, natural law theory says that there are these objective, universal moral truths out there. Things like justice, fairness, right and wrong. They're basically woven into the fabric of the universe, and we can figure them out just by using our reason. So for a human-made law to be legit, it absolutely has to line up with this higher moral law. So where does this higher law even come from? Well, thinkers like Aristotle and John Locke would say it doesn't come from a king or a Congress, but from morality itself. This leads to what's called the overlap thesis, which is just a fancy way of saying that law and morality are fundamentally completely inseparable. You just can't have one without the other. And this brings us to the ultimate hardline conclusion of natural law theory. The philosopher Thomas Aquinas really didn't mince words here. He basically said, a so-called law that violates these basic natural moral principles isn't just a bad law. It's not a law at all. He called it a perversion, a corruption of what law is supposed to be. Okay, now let's step to the other side of the ring. Legal positivism comes at this from a totally different angle. It offers a much more pragmatic answer to where law gets its power. For a legal positivist, it's pretty simple. Law is what we as a society say it is. It's what has been posited or, put into place by human institutions. Think legislatures, courts, that kind of thing. Now, whether a law is morally good or bad, that's a totally separate question from whether it's a valid law. And this brings us to the absolute key idea for positivists, the separability thesis. For them, law and morality are just two different categories. A law's validity depends only on its source. Was it passed by the right people, using the right process? Did it come from a recognized authority? If the answer is yes, then it's a valid law. Full stop. Its moral content is just irrelevant to whether it's legally binding. So let's just put these two side by side, right? For natural law, the source of authority is universal morality, and an unjust command is not a real law. For legal positivism, the source is human authority, and an unjust law, while you might hate it, is still legally valid. These are two completely different ways of looking at where the power of law comes from. Okay, so I know this all might seem a little academic, a bit abstract, but this is not just some philosophical game. This debate has massive, and I mean massive, real-world consequences, especially when a society's laws are used to enforce some profound injustice. Let's take a look at a really famous case, the Dred Scott decision back in 1857. The U.S. Supreme Court looked at the established laws, the Constitution as it was written, the social facts of the time, and it ruled that people of African descent were not and could not be American citizens. This decision legally protected the institution of slavery. Now, from a strictly positivist viewpoint, you could argue the court was just doing its job. It was interpreting the law as it had been put in place by human authority. The decision was legally valid based on its social sources. But this is what critics call a moral vacuum, right? The law has no internal compass to say that something so deeply wrong is itself unlawful. And this created a direct clash. You had Abraham Lincoln, who challenged the decision, not on some narrow legal point, but by appealing to a higher natural law. He pointed to the self-evident truths in the Declaration of Independence, that all men are created equal, and basically argued that this higher moral truth proved the Supreme Court's man-made law was fundamentally wrong. Of course, the conversation didn't just end in the 19th century, not by a long shot. Modern thinkers have added all these layers of nuance, and they've started to suggest that the line between these two theories, well, it might be a little blurrier than it first seems. A perfect example of this is the famous debate between Lon Fuller and H.L.A. Hart.
Fuller, who leaned toward natural law, argued that for something to even be called a legal system, it has to have an internal morality. It's got to be clear, public, consistent. But Hart, a positivist, fired back. He said, hold on, those things are just about making a system effective, not moral. A truly evil regime can have laws that are perfectly clear and consistent. And the lines get even blurrier. Hart himself eventually admitted that for any society to even survive, its legal system needs a minimum content of natural law, like, say, rules against random violence. It's just a practical necessity. And then you have another philosopher, Ronald Dworkin, who argued that when judges face really tough cases where the rules aren't clear, they have no choice but to rely on moral principles, which suggests morality is kind of woven into the fabric of law after all.
So, after all this theory, all this history, what is the bottom line here? Why does this philosophical tug-of-war actually matter in our lives today?
Well, it really boils down to these two fundamental questions. Legal positivism is always asking, is the law valid? Did it come from the right authority? But natural law asks a different question. Is the law just? Does it align with what's morally right? Every single time we debate a controversial law, we are in some way having this very same debate. Just think about it. The civil rights movement was essentially a natural law argument. It said that segregation laws, even though they were legally valid on the books, were unjust and therefore illegitimate. And the entire idea of international human rights, that's built on the naturalist belief that there are universal moral standards that should apply to everyone, no matter what their local laws say. This isn't just history. This is happening right now. And so we end up right back where we started, with a question for you to think about. When the laws on the books clash with what you truly believe is morally right, which one do you follow? That's the core tension of this entire debate. And as you can probably guess, there's no easy answer.